Up and running, up and gunning. Sticky Stocky Sweet TV, Keith Gorgon, Cassava Passava, Man Over Matter. Up and running. Well, England with there, London. Yeah, man, a Vybz Kartel, day one, Privy Council hearing in a London. Yeah, man, I mean, I watch the thing and yeah, kind of really. Well, I see a lot of people are trying to. That's why I say I don't like euphoria. Sometimes people just slow the thing and make the thing run properly. Because there are some people who say them are dip on thing a blog and thing like that. And all them put up is some, bandwagon thing and thing like that. Like them I try the case. They don't really do a dissect thing. Well, we see the man free still because you have now. The judge, them at Jamaica, them not trust themselves. And because them really want to put away somebody, the evidence where them have to go and tamper with it just to make sure that they want to put that. That's some me see this whole thing, And cause a lot of little pothole in this thing. If people really hear the truth and things like that, and them try to spin it and spin it. But you have now, it's one thing we can say still. You have some tough British Privy Council judge, And you can hear them attack and things like that, We have to just watch this thing and hope the best turnout for the man. For that's him. No, because when that go away for what? How much weeks before them come with a judgment. That heartbreaking type of thing, on the edge. So some people come talk about it's a must and things like that. Don't be cool on yourself. And that's all me I tell Because sometimes you see some things and some people just put up some things. Because you have some tough judge. This is one man against the world, Right? And him, remember, Vybz Kartel is a man where been known more than anybody in the Jamaica in the government or in the the law system or whatever. Yeah, so I just say it go. So we have to just watch the space and know, say, well, then we think all the best will come out of it in the end. But stop the euphoria thing, people. Some of you bloggers and come out and try put up on thumbnail or freedom, man I go walk, rate and lele. No. Anyway, that is it. So let's go in at this first day hearing and hear what's going on. Here goes. Boom.
The key point here is there clearly was a breach of Jamaican law. Firstly, reliance was placed on the Charter. One sees that at paragraph 24 of the Crown's case, that acceptance. And secondly, it was expressly argued, see paragraph 23.2 of the respondent's case, that FIPS, which is the leading authority that was applied by the Court of Appeal, was not necessarily determinative because it had been decided before the Charter question and concluded one that was essentially linked to the breach of the Charter.
Sorry, Mr. Southey, it may be me being very slow, but you started that by saying there was no dispute that. I'm just struggling to see what there was no dispute about on this point.
The breach of the Charter was being argued. Yeah. Yes. Sorry, I should have been. Yes, I'm sure that was me. The point I was making that there was no dispute about. There was no dispute that at trial level it was argued that because there'd been a breach of the Charter, the phone should be excluded.
Yeah. Okay.
Is JS2 covering all the relevant technological evidence, including the BlackBerry belonging to Mr. Palmer, or is it not?
No, JS2 is the material that was obtained from Digicel.
Just in outline summary, what did that include? They were the conversations, as I understand it, between... Sorry, no. Sorry, that was rude of me, sorry. Well, I was going to say the conversations between the deceased and his girlfriend, is that right? While travelling, allegedly?
Yes.
Yeah, and then does it also include Mr. Wee, evidence in relation to what he
You mean Mr.
Chow?
Chow.
Sorry, yes, there is evidence, there was communication in relation to Mr. Chow.
Those texts are summarised in the summing up at E4788 to E4791, and we also summarise them in our case at 6227 paras 40 and 41. But essentially they're the ones where the deceased is saying, I'm getting more worried. The second set of texts are from to and from Palmer between the 8th and the 12th of August 2011. But they appear to be of no importance at all. They don't appear to be referred to in the summing up. They were read out to the jury, but they don't add anything. The third set of texts were those from and to Sean Campbell, which are to an extent incriminating, and they are referred to in the summing up. They suggest that on the day of the killing, but before the killing, Campbell knew that the deceased was going to be executed. He had to die. And they suggest that after the killing, he knew the killing had taken place and they needed to get away.
Automatic rule that a breach of the Charter will inevitably lead to exclusion of evidence. It is a more nuanced argument than that. It's important in one sense to be aware of the nature of the breach. And in one sense, the starting point in our submission in relation to that has to be the legislation. Certainly the Court of Appeal was of the opinion by the time that they'd got no evidence that he was an authorised person.
Well, did they get other evidence other than that was produced in the voir dire before the judge, where this matter was fully explored?
Well, the problem is, if you look at the evidence, there's his assertion that he's an authorised person, but he clearly doesn't come within the terms of the legislation, and there's no evidence there was no evidence that I can find that indicates how he gets authority when the terms of the legislation are clear about what's described at times as the second incident, which in one sense for our purposes is actually the first incident, which is the juror who was discharged. But of course the juror who was released from the jury, one of the reasons that is of potential relevance is that seems to put pressure on the trial judge because he can't release any more jurors. And that's where he gets into this difficult situation where he knows that there is a juror who is attempting to bribe members of the jury, but they are allowed to continue to serve. Had they not been allowed to continue to serve, then the jury would have had to be discharged because of what had happened the second time.
So there were three incidents. I don't think you're making any submissions in relation to the first.
No, exactly. That's why I was saying.
So we refer to incidents 2 and 3. 2 and 3.
I was going to use that language, but I was in one sense, in terms of what we're arguing, 2 is 1, but that's where the slight complication came from. But yes,
we better stick with 2 and 3. I think.
I wanted to make clear. I wanted to make sure everyone was using the same language in that way. Yes, absolutely. It's just they're not there present, able to give instructions as the matter's being investigated.
Doesn't the bench book say that it should take place in chambers? No circumstances.
I'm going to come to the bench book. I can't specifically remember that. I was going to take you to the bench book. I can't specifically remember off the top of my head what the bench book says. But
can I just ask, I'm sorry to interrupt. Yeah. When you talked a few minutes ago about current practice, and when you're referring now to the bench book,
yes,
are you referring to Jamaican practice and a Jamaican bench book, or to English practice?
I can't remember what I was referring to as current practice, but I accept the point. I need to be careful to distinguish, albeit, can I make this point, that the Jamaican bench book, which I accept, and I was going to make this point when I come to it, the Jamaican bench book postdates the trial in this case, but what it does, which is why we've submitted it of some relevance, is it makes 2 points clear in one sense. Firstly, it makes extensive reference to English standards, recognising that perhaps unsurprisingly, given that the Jamaican courts apply the fair-minded bystander approach, there is no basic reason to distinguish between English and Jamaican cases. But secondly, it bases what is said in the bench book, unsurprisingly, on historic case law. So it seems to be it's not attempting to set out a new approach. It's on the face of it, it's seeking to consolidate existing principles. One of the reasons why direction is so important in our submission is because it means there is no doubt as to what the jury are being told.
Well, he told, according to the Court of Appeal, he told the jury that she had a personal difficulty that meant she was no longer able to serve.
He told her that.
No, he told the jury.
Sorry, no, yes, you're right. He told the jury, but the problem is that in one sense is part of a package. I mean, because what the Court of Appeals say before that, and they expressly rely on this, what he was told before, and the judge doesn't stop the forewoman doing this, is that she was also going to effectively, as I say, soothe everyone's minds. And the problem with that is that that's her, in one sense, giving guidance to the jury in circumstances where you just don't know what that is.
So what do you say should have happened, ideally?
Well, at the very least, because of the fact that there is, and I've identified where it should be, whether it should be in public or private, but at the very least, and this is the critical point because of this concern about poison, it was necessary to know whether the juror who was going to be discharged had spoken about this incident to anyone else other than the forewoman, and if so, what she had said, and in particular, whether she had made any allegations effectively that the defendants had made threats. Anything really that went to the defendant's bad character.
There wasn't any suggestion, was there, that they had made threats?
Well, the problem was, if you go back, it's why I was drawing attention to
they were simply on remand in the same facility as her son.
Well, it's a bit more complicated than that, my lord. If you go back to 4075, which is what I drew attention to.
Yes, I read it. She was obviously in a very emotional state and she was worried about her son. But
it's a bit more than that. In paragraph, if you look at line 5,
yeah.
Her son says that Kartel, who's one of the defendants, said to him, if ... Then Kartel said to him, if he ... Then it gets stopped. So she is saying...
I'm sorry, where are you reading?
4075. That is in the context of her saying, I don't feel my son is safe. So the question is, in one sense, what is her son told? Is that the basis on which she thinks her son isn't safe?
Well, speaking for myself, I thought it was pretty clear from 14 to 17, where she says, Your Honour, the only thing I'm concerned about is my son's safety. They are there, he is there. They know him. And in particular, one of the defendants was on the same block.
Well, my lord, I don't want to spend too long on this, but that's got to be viewed in context. The question is, why does she think there's an issue with safety?
Well, it's pretty obvious, isn't it?
Everyone in the jury knew that one of their members was trying to bribe them. The reason I draw attention to that is that if one thinks about the underlying purpose of that, it links to the point that's made in Putnam about the importance of isolating the poison. It is a recognition in our submission of the approach in Putnam that once something is going wrong, there is a real risk that information can spread within the jury, that, as I say, to use the language, poison can be spread.
It would follow that juror was not performing his duties as a juror properly, as giving an impartial verdict based on the evidence, and therefore should no longer continue to serve. And if you get that far, then the trial has to come to an end, because under the legislation, in a murder case, there must be a verdict can only be returned of a jury with at least 11 members.
Well, I've slightly overrun, but that's probably a good point to break for lunch.
Yes. Thank you, Mr. Sully.
Sorry, I assume that's probably a little presumptuous.
It's a convenient moment for the court as well. We'll adjourn and resume at 2 o'clock. Yes, Mr. Sully.
My lords, when we broke, I was making submissions about Putnam. Just one thing, I need to move on, but one thing that I would just emphasise about Putnam is the language that Lord Justice Bingham, as he then was, used towards the end of page 759 in that passage where he talks about collective integrity. And he talks about the high regard in which juries are held depending on their collective integrity and their individual integrity. And that's important in one sense because it demonstrates how, in our submission, judges actually, although obviously judges need to avoid discharging unnecessarily because it's a waste of resources, etc. At the same time, judges should not be reluctant if the circumstances arise to discharge the jury, because it's by doing that that the regard of the jury is, in one sense, preserved. That, I think, concludes all I have to say. I think Mr. Buchanan has some additional submissions.
Yes. Yes, Mr. Buchanan.
If it pleases the court, lords and ladies, I just wish to make a couple points, but to start with questions, the clarifications to questions. The first one being raised by Lord Lloyd Jones, and this would have been in relation to in relation to the chamber hearing. Now, in the Jamaican context, the right of the accused to be present at all stages of the proceedings, the concept of the chamber hearing, respectfully, would be that the courtroom would become the chamber. Yeah. So the gallery would be cleared, and certainly the attorneys, the representatives, and then you would have the accused there.
The bench book says that.
That's correct. But my lord, in that situation, because it was a situation within the transcript which reflects that it was actually a conversation between one of the appellants and the son of the jury. She didn't actually see or confronted the appellant. And so she was concerned, so she only heard information, and the inquiry didn't go as far as to find out the truth of that inquiry. And so it led to a discharge. What follows from that is the opportunity would have been lost for the appellants, if questioned, or to say, well, this is not true. And then the judge would have made an informed decision. A juror who is the fruit of the poisonous tree, or the introduction of the poison, no knowledge of how far the poison is. I'm not inviting the court to speculate, but that's all we are left to do, respectfully. And what happens in that situation is we don't know if the pressure arises because there was a situation where these jurors were able to say, I would participate in a bribe, allegedly, or not. And so the verdict that comes could never be a true verdict in light of that. So that's the submission as it connects from incident 2 to incident 3. Now, in relation to the proviso, and I think you had knocked some of the wind out of me, say, Lord Reed, because I would have borrowed your words in the judgment to say that you can't proviso unfairness, you can't proviso injustice. It's just not possible. It would have been an absurdity in the law. The prosecutor has met the burden of demonstrably justifiable.
Can I ask Mr. Buchanan, while you're addressing us on the Charter, as I understand it, the Charter is formally, is part of a constitution. It was made part of a constitution by a constitutional amendment in 2011.
That is
right?
correct.
Was it preceded by some sort of review or report?
My learned friend actually, Mr. Salty Casey, actually made mention of the review and the report.
Oh,
but
right.
what is significant
I'll check my notes. Right.
Right. What is significant that comes from it is that, and we take pride in this, and I'm quoting, I'm paraphrasing our Chief Justice, and it's found, thank you, it's found in the written case at 12 and 13. Yes.
Right, thank you.
Yes, but what we, as I was saying earlier, we take pride to say that this amendment, which is separate from any other Caribbean jurisdiction, was for us, it was made by us, and it was a testimony of our evidence of independence.
Yes.
Where we decided what rights would be protected, and especially the dynamics of the Jamaican society.
Yes.
Is the importance of protecting the least among us. What is key, which I will get to, and I agree with you, and I adopt the words of our Chief Justice.
Yep.
Is the fact that after looking at constitutions all over the world, what we decided is what is important to us. So what we have is a section 13(2)(b), and I know there are many persons, I quote it so much that it becomes an annoyance to many, but 13(2), the protection given to every citizen under 13(2)(b), it is the last flicker or shimmer of light to what it is to be a human.
Yep.
And it separates the state clearly from the human being. And it says, listen, all state actors have a duty not to abridge, abrogate, or breach the rights. And when you do that, you must show that it is demonstrably justifiable. But we do recognize the importance of it, but to submit to the court that the test wasn't done, and so there's no balancing exercise to which could have happened. And because this is our apex court, the apex court could not respectfully substitute what the judge at first instance ought to have done. And in those circumstances, the answer to question A, where evidence was collated, collected, and secured. So secured would have been the request from the police officer. The collection and collating would have been what flows from JS2, the cell site, the text messages, the call positioning, whatever flows from JS2. But all of that would have been no moment. And a key thing before I depart, because I don't want to take up too much time, or
well, you don't have a great deal of time left.
I was being cheeky, Lord Reed, but I didn't know you would figure me out. But the key thing in relation to that aspect is to understand that as we make heavy weight of JS2, what's incumbent on the judge was that in a demonstrably justifiable test, I would submit respectfully that in the absence of JS1, which was the controlled copy that the police officers did not have access to, and where the much counsel from the lower level, which Tom Tavares, KFC, would have said, listen, this is a man from Ireland who would have come to Jamaica, not given any effect to the right, and he gives testimony. This is Simmons, and he doesn't say whether he knows exactly what's in each and every file, and we have nothing to cross-reference, so they would have failed on that test.
And the first part I would like to take you to is at 4073. She says she said, perhaps I should just say, line 24, the witness, that's Catwell, one Friday. So it doesn't identify which Friday. When we weren't at court, I went to visit him, my son, We were supposed to go into the lobby, but him never come out in time. Just as him come out to me, Andrew St John's came in that way. He saw me, he was a bit panicked, and I look at his face, and he was a bit panicked. It's not quite clear who he is, but perhaps he's talking about her son. And then she continues over the page.
Her son or St John?
No, her own son.
But she says her own son didn't come out.
Okay. Oh, he saw me, sorry. In other words, St John saw me.
Yes,
he was
I think so.
panicked, and I look at his face. Forgive me, my lady, yes. And then she goes on to say, shortly afterwards, when he came out, when he came out of the vehicle, my son came in and him said to me, inaudible. I was a bit angry with my son. I was a bit angry because he knew that I was coming and I didn't want to meet up with them. So I think his delay means that St John's would have seen me. So I was angry at him. I think I must be her son now. You know me and I come back because him see me. I never related anything. But she then goes on to talk about her conversation with her son. Near the end of the page, me tell him me and a boy in the jail fight. Me go at the medical centre and him say to me. So there's been some sort of fight. And then over the page, 4074, she says, no, Kartel saw him and say him see him mother a juror, and say St John's tell him, but him not tell the other rest of man. So she seems to have seen, or rather, a cartel appears to have been involved as well at some point. It's not always easy to understand quite what is going on. The next point I want to emphasise, and I'll come to, if I may, the transcript, but the bribe was offered by the miscreant juror on behalf of, or rather in the interest of, all 5 defendants, including Shane Williams. Now you can see why I emphasise that, because the jury obviously did not convict Shane Williams, or the 10 didn't. He was acquitted. Was that it was said, Chow gave evidence that Shane Williams, who he called Terence, was one of the men in the video talking about a killing. And that was the basis on which the case went to the jury. So there was evidence, the judge did allow evidence to go to the jury in relation to Shane Williams, but it wasn't what you might call the same evidence Chow gave against the other 4 men. And then the 4, Madam Foreman...
Do we assume that during that period of time, who else has been... Is there any indication who else is with the judge and the DPP?
I think all counsel, I should say, as I understand it, all counsel are present, but not the appellants themselves. I don't think there's any issue on that.
Right. Thank you. Doesn't actually tell us, does it?
You're right, my lord, but I have a feeling, I don't think it's in contention.
Thank you.
And before he says that he's going to call Madam Foreman, he says that he's going to summon that juror, and he's had instructions to the police.
Yes. In fact, he never does.
Yes.
I mentioned the point about Shane Williams being acquitted. That, in my submission, is not an insignificant point. There are ECHR cases, which I don't have immediately to hand, but I'm sure I can find them in a minute, where problems have arisen, where the jurors have reported to the judge that one of their number is making racist comments. And there was one case, I will come to it in a moment, where there were 2 defendants, and they were both Asian. And the report gets back to the judge. I'm very worried about this. This chap keeps on making racist comments to that effect. But the jury convict one, but acquit the other. The matter goes to Court of Appeal, who say, well, there's no doubt there was reason to suppose bias, but on the other hand, the judge gave directions to follow your oath. The matter went to the ECHR to tell them to abide by their oath. That, in my submission, is a separate question.
Yeah, the lawyers put in Putnam is a real risk that they might have become consciously or unconsciously prejudiced.
Real risk they might have become. That's why, forgive me, my lord, that was I was trying to go by the Putnam test, consciously or unconsciously. Is that something which was going to be in the back of their minds, come what may? There was, however, another course that the judge could have taken, and did take in this case, let's say, not making further inquiries about the juror. At the outset of his summing up, he gave the usual direction to the jury. It was for them to decide what evidence to accept and what to reject. He then gave this direction: decide this case on the evidence and only on the evidence. Do not be influenced by anything you might have been told by anyone, whether by some fellow member of the jury that sat or are sitting with you about some prior knowledge or feeling or view. That is unimportant, and if you act upon that, justice will have miscarried, because that's not the evidence. I hope that I'm making myself absolutely clear that it's the evidence and only the evidence in this case that you have heard that you're entitled to act upon and determine. Having looked at the evidence, examined it, weighed it, determined what facts are, and ultimately what your verdict is, after applying the law, and I will give you to the facts that you find proved. Now, I agree that's a stronger warning, but nonetheless, it's to the same effect.
It's effectively, he's trusting a jury of 10,
Yes.
and 10's not a jury within the Jury Act in Jamaica, is it?
One then gets into what I call a rather metaphysical argument about what is a jury. Clearly, it's 11 people who walk into court. About that, I go back to what I call the first question. Is it really the case that there is no jury if it turns out afterwards that one of them had taken a bribe and was going to acquit come what may?
That's if it turns out afterwards.
Yes.
What if you know going in?
If you know going in, I submit the same follows.
The same.
The judge is entitled to say this: a 10-1 verdict is a good verdict. It's authorised by law. I have good reason, I'm just, as it were, expressing in words what no doubt the judge would be thinking. I have good reason to trust the 10. They will follow my directions. That is good enough to satisfy the requirements of the statute, that there be a jury who decides this. Because there are 11 altogether, and if there are 11 altogether and one of them still takes no notice of what I say, well, so be it.
On your view, can the prosecutor decide that it's okay to allow somebody to remain on a jury, notwithstanding all the scenarios that I've put to you, and the judge can go along with that?
In my submission, in the extreme circumstances of this case, yes.
And how many jurors can the judge allow to remain on the jury, notwithstanding his knowledge that this one's mentally ill, that one's been bribed, the next one's in touch with the deceased via a spiritualist?
Well, no, of course, he can't. The whole problem in this case arises because there were just 11 left. That is where the problem arises from. And my lords, of course, I can see one can think of any number of examples, like the Lordship is putting to be saying, well, in those circumstances, surely the prosecution couldn't just waive it. But this is rather different. This is right at the end of the trial, enormous expense, 56 days, the evidence has all come out, the summing up has been done, and then, boom.
Well, I think we may have reached a convenient point to adjourn for the day. We'll consider where we are in relation to the JS2 point ourselves, and we'll look forward to hearing the remainder of your submissions tomorrow, Mr. Knox.
I will back.
A big sound up here, big tune.
Ja Holy Emmanuel, I woy. Ja Gideon, I'm a Gideon. The Gideon, I'm a Gideon. The Gideon, I'm a Gideon. Well, Gideon go busting out them head again. So much oppression, poor people face right now. Them crying out for freedom. Them crying out for free speech. Then said them want to stand up like them black liberators, like Malcolm X and Martin Luther and the ancient monarchy where come pave the way, sir. Free up black people from tear down them fence, yeah. Gideon, I'm a Gideon. The Gideon, I'm a Gideon. The Gideon, I'm a Gideon, well, the Gideon go busting out them head. I listen, I the power of the Trinity. Give us the teaching of His Majesty, and we know war, no devil philosophy. Not tentacle for man's skin is of no more significant well to the color of his eye. Remember all the war done in 1935.
This is Sticky Stucky Sweet TV with Keith Gorgon. Good, healthy food with the X Factor. So give it a like, share, subscribe, and touch up that notification bell. And that is it. Look at